Hey guys, I've decided to start doing a series of live videos where I give you guys the opportunity to ask me questions and have me answer them in real time through these live videos. I have gotten some questions submitted to me through email already, so I thought I would go through some of those, and if we get some questions while we're going here, I'll be happy to go through them and answer them. I've been having some technical issues trying to get set up here, but I think I've got them fixed. I'll start going through these questions, and if anyone has another question, just ask me while we're going here in the comments, and I'll try to respond as soon as they come through. The first question that I got was from Jose Fernandez, and it is, what should I do if I'm arrested? Well, I don't know where that question meant to begin. Obviously, the first thing that you should do is bond out of jail. And then once you've bonded out, you need to contact an attorney and see what you need to do to start getting your defense together. With most criminal cases, it's important that you get started right away building your defense and working on what it is that you need to do to address certain issues in the case. And that's going to be different in case to case. And that's why you need to get with your attorney as soon as possible so that you can get those things started. I don't know, without a specific fact question, it would be hard for me to tell you what you would need to do. For instance, in a DWI case, you have a time frame that starts immediately once you get arrested about challenging the suspension of your driver's license. You need to do that, and you need to get with your attorney to do that. So it's important to, get with an attorney and not speak to the police or do anything once you've been arrested. Hire an attorney and start on your defense. I had the next question from Andrew Manor, and it is, what is the difference between a felony and a misdemeanor? I guess generally speaking, the biggest difference is the range of punishment. So a Class C misdemeanor is a ticket, usually a fine only, no jail time. A Class B misdemeanor is up to 180 days in jail and a $2,000 fine. Class A is up to a year in jail and a $4,000 fine. Then you have state jail felonies, which are 6 months to 2 years in a state jail facility and a fine not to exceed $10,000. You have a third-degree felony, which is 2 to 10 years, $10,000 fine. Second degree, 2 to 20 years, and up to a $10,000 fine. And then, of course, first degree, which is 5 to 99 or life, and again with the possibility of a $10,000 fine. Above that, we have capital, which can be capital non-death or capital death penalty cases. Generally speaking, that's the difference between a felony and a misdemeanor. But collaterally, there can be other differences. There are many misdemeanors that, depending upon what you do for a living, may not affect you, but then obviously a felony would. There are simple collateral consequences people don't think of. There are apartment complexes that won't take you if you've been convicted of a felony. So generally speaking, those are the differences. If you had a specific question about a specific felony or a specific misdemeanor, we could get more in depth on that. But generally speaking, it's range of punishment. And then, like I said, on collateral consequences, there can be a whole lot of differences. I had a question from Sherry Dunleavy that says, what is the average cost of a criminal defense attorney? And I really don't have any way to answer that. There is not a average cost, I would say. I really, to tell you the truth, don't know what most of my competitors charge. And there's obviously a difference. You know, I've been licensed and doing criminal defense since 1998. So there's going to be a difference between what I'm going to charge and somebody who's only been out of law school 2 years is going to charge, simply because of the experience level that I have. I'm going to be worth more money, at least in my own head. So it's really not, there's no way for me to say what is the average cost of a criminal defense attorney. And also because there's not going to be a similarity between what anyone would charge for a misdemeanor versus what one would charge for a felony. So it's really hard to answer a question of what is the average cost of a criminal defense attorney. I had a question from Jesus Garcia, and it says, if I am convicted of a crime while I am in the United States legally, can I be deported? So the simplest way to answer that is to say yes, but I would need to get more in depth. So it depends on what you mean when you say while I'm in the United States legally. So if you're a lawful permanent resident, for example, you could be convicted of a crime that was serious enough to have the government, the U.S. government, move to revoke your residency and then have you deported, okay? If you become a naturalized citizen, then the answer is no. They can't undo your citizenship. If you're simply here on a visa and you commit a crime, then obviously they could revoke that visa. So to some degree, it depends. When you say here in the United States legally, it would depend on what status, because if you are an LPR, not every conviction would lead to the government seeking to remove your status and have you deported, but certainly there are some. So without having a specific example of the crime, it's hard for me to answer that. Ronald Behringer asked me, why do I need a lawyer's help if I'm accused of a crime? Well, I mean, the reason is because the prosecution's job is to prosecute you. We have spent years studying the law and learning how to practice law. And without me there to defend you, how would you know what questions the prosecutor might ask you that you can and can't answer? I mean, there's not an instance where I can think of where it would be a good idea to walk into a courtroom and try to defend yourself of a crime. Sure, lots of people go to traffic ticket court by themselves, and that's a different situation because there are no lifelong consequences typically with a traffic ticket. But being convicted of a crime does and can have lifelong consequences. So that's why you're going to need the help of an attorney should you find yourself in that position. I had an anonymous question of what types of questions should I ask a criminal attorney? So that's a good question because hiring a lawyer should be to you very important because, again, the consequences could have lifelong an impact for the rest of your life. So what I would say is if I was accused of a crime, I'm going to treat it like anything else. I'm probably going to go see 2 or 3 lawyers, and I'm going to ask them about their qualifications. I'm going to ask them if they've ever handled a case like mine. Have they tried jury trials? Do they try jury trials? How many have they tried? Because there are plenty of lawyers that don't try cases. There are plenty of lawyers that just plead everything. And so you're going to want to ask the lawyer that you're interviewing all these questions. And at the end of the day, you need to hire whomever you feel most comfortable with, whomever you feel you can communicate with. Because without the ability to communicate, how can you feel comfortable about the advice that you're getting from this attorney and the decisions you're going to have to make? So really, the questions that you're going to ask are going to change depending on the circumstances. These days, there are a lot of resources you can use to look up and find out information about an attorney. You can look on the clerk's website run that attorney's name, see what kind of active cases they have, how many cases do they have. There's a lot of ways for you to find out information, and people should really do that. Here's another question. Do all criminal lawyers go to court? And I had to stop and kind of think about this. I mean, I don't know how you could be a criminal attorney and not go to court, because unlike civil law, really all of our work is done in the courtroom, uh, especially when you're talking about jury trials. But even in the interim, that's when we interact with the prosecutors and do most of our work is in the courtroom. So I don't know what the intent was behind asking, do all criminal lawyers go to court? Now, if the question was meant to say, do all criminal lawyers go to trial? That answer is no. There are plenty of lawyers who do not go to trial. They're not going to, want to come out and tell you that. But again, you can look that up in public records. If an attorney tells you they've tried a case, you should be able to look it up and verify. Let's see. Do I have to tell my attorney everything? So the answer there is very clearly yes. First of all, our conversations are privileged, and I can't share that information. If I did, I would be in violation and I could be disciplined by the bar. The worst thing you can do is not tell me something and then I get blindsided by it. If I don't know about it, I can't prepare for it. If I know about the bad information, I can figure out a way to prepare for it. I can deflect, I can do something. But if you haven't told me and then it gets sprung on me, there's no coming back from that for me. What is the role of the grand jury? In the state of Texas, every felony must go before the grand jury to determine whether or not that case will go forward. The grand jury hears the evidence from the prosecution only, and then issues either a true bill or a no bill. If they true bill, the case proceeds forward through the felony court system until it's ultimately resolved. If it's no bill, the case dies right there. Now, in the grand jury, only the prosecution is allowed. A defendant can choose to testify before the grand jury. However, his lawyer is not allowed in the room with him. So, as you can imagine, that very rarely happens. There are times when we, as defense attorneys, prepare what we call grand jury packets, which is a packet full of written information about our client, our take on the case, the charges, and whatever the deficiencies are. And we will present that to the grand jury through the prosecution for the grand jury to consider. And oftentimes we have been successful with that. Oh, here's a good question. Can you tell your attorney you're guilty? Yes, of course. That's not, when I look at a case, my analysis is, can the state prove the elements beyond a reasonable doubt? It's not, well, this guy's guilty, so he just needs to plead anyway. That's not how this works. It's, can the state prove the case? It matters to me not whether you're guilty or not guilty. It matters to me what the evidence is, and can the state sufficiently use that evidence to convict? If not, then we're going to win regardless of what you think your guilt or innocence is. Why won't an attorney take my case? I don't have a good answer for that. It's going to change and be independent for that attorney. I do know attorneys who won't take certain types of cases for any number of personal reasons. Maybe the attorney that didn't want to take your case felt like you two couldn't get along. I mean, this is real world here that we live in, and not everyone works good together. You and I may not communicate well together. I may not feel like you are going to listen to the advice I give you. I don't know why an attorney wouldn't take your case. Sorry, I'm reading through questions here. What happens if I don't show up for court? So typically, if you don't show up for a scheduled court setting, the state will move for bond forfeiture and a warrant will be issued for your arrest. Now, that having been said, if there are certain circumstances, that you were in the hospital and you can get me documentation on that, I can fix that. But again, that just goes back to communication. If you had communicated that to me before, I probably could have gotten the court date changed. But generally speaking, if you don't show up for court, you're going to get a warrant issued for your arrest. Here's a question: should I take a polygraph? The answer generally to that is no, especially if you mean that the police are talking to you without the benefit of your attorney being present. You shouldn't be talking to the police without your attorney present. And if they want you to take a polygraph, there's no reason you should do that. That means they don't have anything and they're looking for something to get on you and use against you. Polygraph results are not admissible in court anyway. There have been times that I've had clients take a polygraph at my direction with my expert, knowing that it won't be used in court, but sometimes it sways the prosecution. Sometimes we can get that before the grand jury and they'll consider it. But generally speaking, if you're talking about the police issuing you a polygraph examination, no, you should not do that without having your attorney present, talking to your attorney about it, and making an informed decision. Does my old criminal record matter? So yes, your criminal record is your criminal record for life. An easy example is DWI. As you get more DWIs, the punishment progresses, right? So let's say you had a DWI 20 years ago, you've already forgotten about it. And then 5 years after that, you got another one. It's been so long ago, 20, then 15 years ago, you really don't even think of them anymore. But now you find yourself with a DWI. Even though those older ones are 20 and 15 years old, you're still going to be charged with DWI third, which is a felony. It works the same way for enhancement of penalties on other cases. Hello, cousin. And so, yes, your old criminal history matters. It never goes away. That's again why you should never walk into court without a lawyer. Looks like I've pretty much gone through all the questions I had submitted for today. So that'll do us for today. I'll cut it off, and I'll be doing these on a regular basis. So as y'all submit questions, I'll try to answer them to the best I can. Everyone have a great day, and we'll see you next time.